What if I told you that debt in your name can be assigned to a trust and challenged or discharged privately without going to court? In this video, I'm going to break down how assigning debt to a trust puts you back in control, why the creditor might lose jurisdiction, and how to use this strategy to shield yourself from liability. I've studied trust law, commercial law, and administrative remedy, and I'm here to help you understand the method that few lawyers will ever explain. Now, before we dive into this video, this is not financial advice. This is not legal advice. Make sure you do the due diligence. Make sure you stay educated. You dig me? Look this stuff up. You know what I mean? Don't just take everything that I'm saying for face value, go and then say, well, Nicholas told me to do this. No, I'm not telling you to do that, my baby. So make sure you do the due diligence. Everything that I'm talking about, make sure you cross-reference it and go look it up online yourself. You got glasses, Nick, today, so y'all know I'm standing on business today. Now, also, if you're brand new, hit the like button, hit the subscribe button. Make sure to stay tapped in. We want to make sure we are at the top of the algorithm so that people can see the information that people do not talk about. Plenty of gurus will talk about trust and they'll talk about, how to use a trust to discharge debt, but they never truly explain the intricate details that you need to know in order to utilize your trust properly. Okay? They don't even talk about the mistakes that we make. All right? So by the end of this video, you'll understand how that works. All right? Now, a couple of things we're going to be talking about is why assigning a debt to a trust works. We're going to be talking about the legal foundation for assignments. So we're going to be breaking down the UCC codes. We're going to be breaking down the CFR codes. We're going to be breaking down the different laws that this process is backed by. We're going to talk about how to step-by-step assign your debt to a trust. And lastly, we're going to talk about how to make sure that you properly enforce it in case a creditor fails, in case, you have to go to court. We're going to be talking about these things. So make sure you stay all the way to the end so that you can get this game. All right. So let's dive into it. Now, why assigning debt to your trust works. Okay. Number one, a trust is a separate legal entity, not you. All right. Given the fact that the trust is a separate legal entity, then understanding that when you start to assign the debt to a separate entity, it now is the obligation of the entity. You dig what I'm saying? So what happens is when you assign the debt to a trust, it creates distance between you and the obligation. All right. But also at the same time, you are transferring administrative control to the trust to handle that matter privately. And this shifts the liability, standing, and authority. So if you didn't sign as the trust, they may not have lawful claim to collect from you. So there's benefits in making sure that you have a trust so that you can assign a debt to a trust. There's benefits in making sure that you now shift the conversation to a different entity because it takes the liability out of your name. Okay? Now, I want to talk about the legal foundation for debt assignment. So when it comes to the legal foundations for debt assignment to your trust, the first place that we kind of want to come to is UCC 9-203, which the attachment and enforceability of security interest, proceeds, and supporting obligations and formal requisites. Okay. It says a security interest attaches to a collateral when it becomes enforceable against the debtor with respect to the collateral unless an agreement expressly postpones the time of attachment. All right. Except as otherwise provided in the subsection through a security interest is enforceable against the debtor and the third parties with respect to the collateral only if value has been given, the debtor has rights in collateral or the power to transfer the rights in collateral to a secured party, and one of the following conditions is met. A debtor has authenticated a security agreement that provides a description of the collateral, and if the security interest covers timber to be cut, a description of land concerned. The collateral is not a certificate security and is in the possession of the secured party under section 9-313 pursuant to the debtor security agreement. Okay. So long story short, okay, it also talks about the aspect of a new debtor, but it talks about, just in lamest terms, a security interest attaches when a debtor has rights in the collateral. Okay, so understand that as a debtor, you are quote unquote the collateral, and you can essentially, you have security interests. Okay, so then we dive into UCC 3-301, which is the person entitled to enforce the instrument, which essentially says that a party must be entitled to enforce the instrument. Okay, meaning they must be the holder in due course. Okay, and if they don't hold it, they still, in some way, shape, or form, have possession or security interest to it. So it goes hand in hand with 9-203 as well. But then we dive into 26 CFR 301.7701 trust. It breaks down, and this is the trust that you'll want to be creating, an ordinary trust. The trust itself, it recognizes that trust relationships can be an administrative role. Okay, so in general, it says the term trust, as used in the IRS code and the IRC, refers to an arrangement created either by will or by inter vivos declaration, whereas trustees take title to property for the purpose of protecting or conserving it for the beneficiaries under ordinary rules applied to chancery or probate courts. Usually beneficiaries of such trusts do no more than accept the benefits thereof and are not the voluntary planners or creators of the trust. Okay, hold on, let me just go ahead and gloss through this real quick because it's just breaking down what a trust is. Generally speaking, an arrangement will be treated as a trust under the Internal Revenue Code if it can be shown that the purpose of the arrangement is to vest in trustees responsibility for the protection and conservation of the property for the beneficiaries who cannot share in discharge of this responsibility, therefore are not associates in a joint enterprise for the conduct of business for profit, right? So you can use the trust as an administrator for your person, okay? And even when we break down just the certain aspects of, the trust, we're going to talk about how to properly put together that trust so that it doesn't become invalid. Because we've talked about concepts of you essentially, creating the trust and you being all three, the grantor, the trustee, and the beneficiary. And yes, you can do this, but this can be ineffective in most cases, and this is why I'm kind of redoing this video in a sense. All right, and particularly talking about the use of trust and how to properly assign debt to a trust. All right, so it's also tied to the restatement of trust. Okay, trust can receive property obligations or legal claims if it is assigned. Okay, so if we go to the restatement of trust, boom, boom, boom. It says, in summary, a trust restatement is a way to make substantial changes to your trust by creating a completely new document while keeping the original trust identities, name, date. It's often a better option than multiple amendments when you need to make significant changes or consolidate previous amendments. Okay, where exactly did I want? So through the restatement of trust, it essentially just backs up the fact that you can assign debt to your trust. Okay. And then also under the aspect of contract law assignment, you can assign things. You can assign any contract to a separate party, obviously, if that party agrees to take over that obligation. So even common law allows you to be able to assign contracts over. And remember, debt is, a contract. Okay, it's a claim. All right. So I want you to also understand that assignment isn't hiding. It's lawful delegation of responsibility. Okay. So number one, the reason why assigning a debt is beneficial, to assigning a debt to your trust is beneficial, is because back to the fact that it creates that distance. And this is why we have these laws put in place so that you can be able to shift the narrative. And these are the laws that back it up. UCC 9-203, UCC 3-301. 26 CFR 31.7701-4, Restatement of Trust, Common Law Foundations, and Common Law Contract Assignments. Okay? So the reason why you would essentially put it in your trust or assign the debt to your trust is so that you can separate yourself from it, or moreover, because it's not that you'll be removing that obligation completely, but you'll be creating distance. So now it's not under your personal name, it's under a separate entity. So let's break down step by step how to assign a debt to a trust, okay? First thing you want to do is you want to create your trust. Now, if you don't know how to create a trust, you can go watch my YouTube video on trust and discharge. I break down how to create a trust, or you can tap into the Complete That Guide. I have a whole kit breaking down how to create a trust, okay? Private, irrevocable is recommended. Now, if you're going to do a private trust, you have to make sure you create a private declaration first and create your trust first, and then you want to go to the IRS website and get your irrevocable trust EIN, okay? Number two, you want to appoint a trustee. And in order for this to work, you cannot appoint yourself as trustee. I know we talked about this in previous videos of how you can appoint yourself as trustee, but this is why I'm recreating this video. You want to make sure it's somebody that you trust. You want to make sure it's somebody that is not you, because essentially if you do that, especially if you're the grantor, it may make your entire trust invalid, okay? And we're going to talk about that in a second. Number three, you want to draft an assignment of the debt agreement. This includes the account number, creditor, description, city, sites that the trust accepts, assignment as the administrator or agent. And you want to notify the creditor with the letter of assignment. You want to notify the creditor of notice of representation by trust. You want to send them a debt validation or conditional acceptance from the trust. You want to start communicating with them through the trust once you assign it to your trust. See, when you have that paperwork that says, hey, look, I assigned this debt to the trust, just notify the company. It's not no extremes that you have to do. No online, oh, do I have to do this or do I have to do that? If you write on a piece of paper with their signature of you assigning your debt to your trust, and you notify that company who quote unquote says you owe them a debt, this is how you assign the debts, okay? Yes, you can do this, but you still have to make sure to notify them, okay? I think a lot of people are in the space of where they'll do something and they think that they don't have to notify them. I mean, if you don't notify them, how would they know that you assigned the debt? You know, especially if you're doing it privately, all right? Now, the trust becomes a point of contact, not you. So I want to talk about real quick, because another thing is, okay, bet. If in a private trust, can't you be all three? Yes, absolutely. You can be all three as it pertains to a private trust. You can technically be the grantor, the trustee, and the beneficiary, but it comes with those limits and consequences, okay, as it pertains to debt assignment, discharging debt, administrative remedy, okay? So here's when you can be all three in a private trust. In a revocable living trust, especially for estate planning, one person often serves as the grantor, trustee, or beneficiary. This is allowed because it's designed for personal use, not for asset protection or remedy, okay? But then we dive into those legal traps if you hold all three roles. According to trust law, one person holds all three roles without any separation of interest. The trust can be deemed invalid because there's no split in equity in legal title. That means that there's no separation of control versus benefit. There's no true fiduciary relationship. And the courts may treat it like you never created a trust at all. Okay, so you have to be very careful when you are creating your trust. It's maybe on the aspect of doing it for estate planning, but if you're planning to do the remedy process, it's best if you appoint a trustee. Now, let's just talk about it in the case of debt discharge and remedy use. To keep your trust private, valid, and effective, especially when challenging public claims, the best practice is you, the grantor, or your entity, if it's your business. Number two, a trusted person or entity you appoint. So it could be a business, it could be a LLC, it could be a family friend, it could be a church, it could be a pastor, whatever the case may be. Somebody that you trust, that it doesn't have to be like no celebrity, no coach, no guru. You know what I mean? It doesn't have to, it also an attorney, but it doesn't have to be an attorney. It just has to be somebody who knows how to handle paperwork, okay? And have some level of understanding of trust and, communication, all right? But even that, if you have somebody that's willing to accept your letters and be that trustee, you can pretty much just go through them. You can still do the trustee work, but that person is going to be the one doing the delivery, the communicating, and attaching their name as the trustee. Okay, this is important because this can create legal distance in terms of it shields that liability if you appoint someone else. It also preserves that separation of roles, so you're able to overcome that invalidity of your trust, and it helps you navigate remedy without entanglements. All right. Yes, you can create a trust and you can put all yourself as all three, but then they will look at it as if, you're still the same person. Okay. So a question would be, okay, for a trust versus an LLC, I'll do a video on that in particular, probably tomorrow or some point this week, so that you guys can be able to understand how to use the trust versus the LLC in the debt discharge process. Now, you can be all three, but you shouldn't if your trust is for administrative, legal, or asset protection purposes. Okay? Split the roles to keep your trust private, lawful, and respected. Now, another question you can say, well, okay, how can I find a trustee? What type of people do I appoint? So finding the right trustee is probably the most important aspect to this process, okay? Now, if you're planning on using the trust for debt discharge, asset protection, and administrative remedy, here's the 3 key qualities that your trustee should have, okay? Now, this is something that they don't talk about, all right? So make sure you hit the follow button, make sure you hit the like button, make sure you hit the subscribe button if you're brand new. If you're watching this on YouTube, we're live on Twitch right now, but for the people that's watching this on YouTube, make sure to hit the like button, make sure to hit the subscribe button, okay? Because these are the things that people just do not talk about, especially in this community. Okay, they'll say trust this, trust that, and they won't tell you how to do it and how to properly do it so that you are able to actually, use it effectively. Okay, so number one of the key qualities your trustee should have, they should be trustworthy and private. They must follow instructions and maintain confidentiality. That's numero uno. Number 2, no personal drama or loose lips, okay? Your trustee must honor privacy, okay? Number 2, they must be adversarial, okay? They must not be an adversary, okay? They must not do something adverse to you or be willing to, okay? So it is not a party to, they're a person that's not a party to the debt or the dispute, so meaning they aren't a part of the collection process or the debt collector, and you want somebody who won't attract liability or be a conflict of interest. Okay. And number 3, they have to be competent with paperwork or willing to learn. Okay. So they don't need to be a lawyer, but they should be responsible with handling administrative documents or notices. Okay. So in some cases, you may need to pay somebody, or sometimes it has to be somebody that you know, love, and trust that is willing to do that type of work for you. Okay. Here's some common options: a trusted family or friend. Okay. They're easy to appoint. They know you, but they must stay neutral and responsible. Okay? You guys gather that. Number 2, a private fiduciary or consultant. This is probably somebody you'll end up paying, professionally experienced, and they may charge a fee. Number 3, your private entity, LLC, or business trust. You can keep it in-house, but it must be properly structured. Okay? And we'll probably touch a little bit on that, your private entity. A faith-based entity or a private ministry. This offers separation from you and must respect spiritual and legal integrity. And then lastly, an attorney or a CPA. It makes sense, right? They're going to have the legal understanding, but they may push statutory thinking and not private remedy. So you have to be careful when it comes to appointing an attorney, because they're going to maneuver based off of state laws and things of that nature. Now, avoid these type of trustees when you're appointing a trustee, okay? Anyone you owe money to, I will tell you, somebody that who will not be an adversary to you. If you owe them money, do not appoint them as a trustee, okay? Some people say, well, look, Nick, I want to work with you, this, that, and the third. Look, my baby, I don't know you like that. You know what I mean? I'm not in a business to be a trustee. At least not right now. Maybe later on. Okay? Anyone emotionally unstable or gossipy. Okay, I'm definitely not that. Government officials or public institutions. You definitely don't want anybody public or anybody in the government right, to handle your trust. And creditors are people in financial trouble themselves. So somebody who is in a dire situation, you do not want to appoint them as a trustee. Make sure it's a trusted family or friend that is responsible. Okay? Now, the trustee is the executor of your will while you're still alive in commerce. Okay? You don't need a celebrity or a guru, just someone that is loyal, responsible, and not you, so that you can keep the separation of roles. Okay? And if needed, you can even create a nominee trustee for appearances while holding private control through a contract. So that's probably the most important part of a point of making sure that your trust is properly structured for debt discharge. You want to make sure to appoint a trustee, and you don't want it to be you. Okay, I know we talk about that you can be all three, but that's particularly for estate planning. But if you're more on the remedy side, and this trust is just specifically for asset protection and debt assignment, you want to make sure you have a trustee. Okay. Now back to the fact of, after you do the assignment, you send that letter of assignment, you send that notice of representation by the trust, and you take them through the debt validation and conditional acceptance process through your trust. Now you can write all these letters and you can literally send it through your trustee, right? And you can have your trustee be able to hold and manage these files and keep them for safekeeping and things of that nature. But it has to be somebody that is willing to do that work and is willing to handle that paperwork. They don't have to write everything, but it's just being able to maneuver and pass on that paperwork. Okay. Now, here's what happens next. The best case outcomes, and I'm telling you, this is the best case of outcome. Number one, the creditor fails to validate. Okay, if they fail to validate, that means that they default via the trust. Okay, if the jurisdiction is challenged, this can end up being dismissed or ignored. Okay, number three, administrative remedy offered via the trust. So what can happen is that you actually win and you get that administrative remedy. Okay, and they say, you know what, you're absolutely right. And number four, you preserve your name and limit exposure. Okay, so in most cases, you don't have to have your name on a book. It'll be trust versus Bank of America. Okay, now the tools that you want to use are the same exact tools that I talk about in all of my videos. The administrative process. You want to send a conditional acceptance. You want to send a notice of tender. You want to send a private payment voucher if you decide to do that. And you want to send an affidavit of truth that is signed by the trustee. You dig what I'm saying? It's the same exact process. There's no point of overthinking debt discharge. All we're doing is just adding on a trust. All we're doing is appointing a trustee and sending it through them. You get what I'm saying? They're the middleman. But you have to make sure that you aren't doing it through your name, or else it won't work the same. You can still use it. If you're going to do it that way, you might as well just do it as a debtor. Okay? Now, the moment you stop responding in your name, you actually reclaim power, okay? Because they're going to keep treating you like the straw man. But if you're not maneuvering like the straw man and you're maneuvering through a trust, they can't treat you as such. All right? Now, here's some mistakes to avoid to wrap this up. Number one, don't mix the roles, okay? You can't be all three. You can't be the grantor, the trustee, or the beneficiary. Can't be all three, okay? Number two, you don't assign it to an invalid or unformed trust. So if the trust isn't properly formed, don't assign it to it. Number three, you forget to document and send certified mail. Okay? The certified mail is that's a witness that they received it. Okay? That you have sent it. And another mistake is assuming that this discharges everything. Okay? You must still follow through with the remedy. So even though you can send these letters and you can say, oh, I'm doing this, I'm doing that, I'm doing it through the trust, and you think that automatically your debt is just going to be discharged just because you did it, unless you get that remedy either by a court or they say directly, yes, your debt has been discharged, and they send you that information, the accounting, it doesn't discharge everything. Okay? Some situations may require different maneuvering, different understandings. So you have to be careful. It's not always a one size fit all in certain cases. Okay. Now, here's what you do want to do. You want to make sure to keep clean records. You want to remember to respond timely through the trust. So if you have 30 days to respond, make sure you're responding within those 30 days. And number 3, only use lawful and non-fraudulent processes. People will talk about, oh, file with the FTC, and people will talk about use the UCC1, and people will talk about use a 1099 and use an OID. And I was one of those people, right? And it's not that those processes are fraudulent. It's just more on the aspect of how can we put legal merit behind it? How can we actually take it and actually win in court? How can we use this to communicate? Because yes, we can file a 1099, but now you got to have an argument as to if you are considered a financial institution, okay? Or you're gonna have to then argue that you're the actual creditor, okay? And then we have this sovereign citizen conversation that most times, courts will just laugh at that, okay? You go into court and you talk about you're a sovereign citizen, they're probably just gonna laugh at you. But when you maneuver in a different way and you say, hey, no, I ain't no sovereign citizen. I got me a trust that's going to do the communication on my behalf. You dig me? So lastly, assigning a debt to your trust isn't just about avoiding liability. It's about reclaiming jurisdiction and putting the system on notice that you're no longer playing defense, okay? The benefits of assigning that debt to your trust is to create some type of distance from you and the debt itself. This could be a quick way for it to get out your name and potentially get off your credit report, okay? But I'm not promising that, okay? You still got to do the work. You still got to make sure to follow through with the process. You're not going to send one letter and hope that it's going to discharge your debt. That's not what I'm telling you to do. And I'm also at the same time not telling you not to pay your debt. If you can pay your debt, if there's a $200 debt that you can afford, pay it now. Don't go through this whole process signing to a trust just because. $200, just pay it. You know what I'm saying? If it's $1,000, just pay it. You know what I mean? Now, when we get up there, 5,000, 6, 7, 10. You know what I mean? Unless that 10 is like $100 to you, you know what I mean? Like, do what you got to do. You know what I mean? Now, if you want to learn how to do this and understand this properly, download the Complete That Guide down below. You can go ahead and tap in, gather all the information there. I upload different templates and different, one-pagers breaking down step-by-step processes. You'll be able to get that in the Complete That Guide. Number 2, if you want to work with me one-on-one, if it's not about you having a trust, I'm not going to be your trustee. I'm not going to discharge your debt. This is for people who want to fix their credit, get funding, or for those people that have a credit repair business that they want to grow and scale. Tap into my one-on-one mentorship. So it's a plethora of things I can help you with and consult you with, but it's not going to be debt discharge, okay? I will be able to consult you and bring clarity around my YouTube videos. But if you watch every last one of my YouTube videos, you tap into the Twitch stream, the link will be in the description. I think you'll become a master, okay? And lastly, follow me on Instagram and Twitch at biz.nick and biz_nick on Twitch. The links will be in the description. My last question is, have you ever thought about shifting your debt to a trust? Drop your questions in the comments below. Remember to like, subscribe, turn on the post notifications so that you can get updated every time I post a video. If you've gotten all the way to the end, comment the word discharge, and I'll see you in the next one.